Good morning and half a day. The Committee on General Government Operation Appropriations is now called to order. Today is Thursday, September 14, 2023, and the time now is 9 o'clock. In compliance with the Open Government Law, the notice for this public hearing were posted on the Guam Public Notice Portal KGTF PBS Channel 12 and disseminated via email to all senators and all main media broadcasting outlets on Thursday, September 7, and then on Tuesday, September 12. The items that we'll be discussing this morning, there's actually two bills. But the first one is Bill 30-37 COR, sponsored by Senator Brown, authored by Senator Brown, co-sponsored by Senator Barnett, Senator Frank Blas Jr., Senator Tom Fisher, Senator Telo Tadegui, Senator Chris Duenas, and Senator Jesse Lujan. An act to add a new section 4101A, 1D of Article 1, and to add a new Section 4203.4 to Article 2, both of Chapter 4, Title 4, Guam Code Annotated, relative to the prohibition of employment in the government of Guam for individuals convicted of official misconduct under the provisions of Section 9, Guam Code Annotated 49.9. The physical note for Bill 3037 COR was requested on February 8 and was received and disseminated to all senators via email by the Committee on Rules on February 16. Those participating on Bill 30-37 are invited to the panel. Is there anybody that signed in? If anybody signed in, please join us at the panel, if you plan on testifying. That being said, I will now read the rules for this public hearing. Please provide my legislative staff with any document for distribution for photocopying. Panel members are asked to remain in the room for question or for additional testimony may be desired by members of the committee. Question and testimony shall be confined to the substance or nature of the agenda. Personal inference as to the character or the motive of any senator or any individual testifying is not permitted. Any violation of this general rule of conduct will result in removal from the public hearing. Proper form and decorum shall be practiced by all present in the public hearing room. For these proceedings, individuals who fail to maintain proper form and decorum will be restricted from participating and will be escorted and removed from the room. When you speak, please make sure the microphone is on and that you speak into the microphone. Please state your name and your title for the record. The panel this morning providing oral testimony is the Attorney General, Mr. Doug Mullen, and Yolanda Elliott, and Gloria Rudolph, okay? Or you just signed up, okay. All right, it'll be just the Attorney General. With that, I'd like to ask, I'd like to thank my colleagues for attending this public hearing. We have the author of the bill, Senator Brown, Senator Telo Tadegui, Senator Jesse Lujan, Senator Roy Canata, and Senator Frank Blas. And I'd ask Senator Brown to give her opening statement on her bill.
Thank you very much, Mr. Chairman, and certainly appreciate the opportunity of finally having this bill 3037 heard by your committee so that hopefully this term we have an opportunity to move this bill forward. I think it's important with regards to our respective roles for all of us that work in the government of Guam. We're all public servants. And I think it's very, very important to ensure that all of us in our respective capacities are performing our job in the proper way and not misusing our positions in any way to harm or benefit someone else that's not supposed to benefit from public resources. I do want to begin by at least defining what under our current law official misconduct is. And so I just want to read from our current statute, Mr. Chair, with regards to official misconduct as defined and punished. It says a public servant commits a misdemeanor if with the intent to benefit himself or another person, or to harm another person, or to deprive another person of a benefit. A, he commits an act relating to his office but constituting an unauthorized exercise of his official functions, knowing that such an act is unauthorized, or he knowingly refrains from promoting a duty which is imposed upon him by law, or is clearly inherent in the nature of his office. I think one of the things that's lacking these days, or at least eroding, Mr. Chairman, is the lack of public confidence public trust with regards to those of us that are serving, or supposed to be serving our people in our respective capacities. And that is simply every position in the government of Guam where an individual is being paid for by the taxpayer dollar or money provided on behalf of the taxpayers of Guam. One of the things we found out not too long ago was that anyone who's actually not just charged, but actually convicted with official misconduct is not outright prohibited from being hired in the government of Guam. We were told by the previous Attorney General in his determination that anyone convicted of official misconduct, that if they wanted to be rehired in the government of Guam, it literally is left up to the discretion of the director of a department or agency. And I think when these type of offenses have been committed against our people, when an individual has already been serving in a public capacity where they have a responsibility to ensure that they properly carry out their duties, committed offense that harms our people, I am of the position, and this bill is of the position with my co-sponsors, that that individual who's been convicted of official misconduct should not be allowed to be rehired in the government of Guam. Now, some people argue, Mr. Chair, that, oh, well, you know, we all make mistakes, and granted, we all make mistakes. But when someone's actually convicted of official misconduct, they should not go through their learning curve at the expense of the Guam taxpayer. Especially, as I mentioned earlier, our people already have a sense of lack of public trust in the government overall. The fact, Mr. Chairman, every year that we see less and less of our people, including those who are registered voters, literally falling off the list and not choosing to vote, not choosing to participate in the elective process, to me is a very clear sign that a lot of our people are very disappointed, they're very jaded, and sometimes they feel that even their individual vote that we all value doesn't have an impact on the government that they would like to see, especially a government that they would like to see be responsive to their needs. So with that, Mr. Chair, I'm providing my opening statements with regards to Bill 3037 and look forward to the testimony that's being provided on behalf of our public on this bill. Thank you for the opportunity to comment.
Thank you, Senator Brown. I'd like to ask the Attorney General, Mr. Moylan, to please give his testimony. Thank you.
Hafide, good morning, Chairman San Agustin, Senator Brown, Senator Kinata, Senator Blas, Senator Lujan. This testimony is submitted on behalf of the elected office of the Attorney General and the people of Guam in support of Public Law, Bill number 30-37. Official misconduct is a catch-all criminal law that the people of Guam as plaintiffs in criminal cases use to prosecute government officials that break our laws while serving us. Official misconduct is defined as a public servant commits a misdemeanor if, with the intent to benefit himself or another person, or harm another person, or to deprive another person of a benefit. It goes further to indicate that the act must be relating to the office and constituting unauthorized exercise of his official function. And the statute goes further to say that knowingly refrains from performing a duty which is imposed upon him by law. Guam's criminal law creates a nexus between working for the people and conduct. Because government employees are stewards or fiduciaries of the people's money, you senators have deemed it criminal and subject to imprisonment when an employee abuses that position to enrich themselves or hurt another. I endorse that criminal statute. More importantly, I am duty-bound to enforce that criminal law among those same officials that I must work with daily in representing my client. My client is collectively the people of Guam. My client is not individual government officials who are often the potential subjects of government corruption investigations and prosecutions. In this upcoming fiscal year, we have now entrusted our government employees with a $1.1 billion budget and given most of them an unprecedented 22% pay raise. This creates a recipe for temptation in an aura of absolute power. Money is power. However, unlike personal wealth, government employees are given access to large sums of money which only successful corporate executives and entrepreneurs would otherwise have access to. Bill 30-37 is an attempt to temper that power. It sets a standard along with the AG doing his or her job, hiring tough and dedicated prosecutors like Gloria Rudolph to prosecute official misconduct. At the AG's office, we are responsible for investigating and prosecuting government officials. However, the power to convict remains the providence of all of you as jurors that listen to what happened and to decide guilt. Bill 3037 keeps the fox out of the henhouse and proactively protects our taxpayer monies to make our jobs easier. Guam does not have enough attorneys and prosecutors. Thank you for passing the budget law that keeps this office strong, and thank you in advance for continuing to keep us strong so we can protect you. As AG, we often must work with other law enforcement officials like the public auditor and the Guam Police Department to investigate and uncover wrongdoing once it has already occurred. Those that we can prosecute are likely the tip of the iceberg, and several others were able to cover their tracks or beat it on a technicality like statute of limitations and get away with it. Bill 3037 fights crime from the other end by not allowing those convicted criminals to get back into positions to steal our money or hurt others. As is often the case in government corruption prosecutions, government officials attempt to cloak themselves in only doing their jobs. Official misconduct does not allow that simple defense because it looks not just how the official did the work, but more importantly, what their action did in enriching themselves or hurting someone. My recommendations to improve Bill 3037 include disgorge the salary paid to the government official who was hired, requiring the person to pay back the people of Guam, which is basically removing any argument they might have in the civil courts for a quantum merit argument that they were hired, they were providing a service. And require the termination of any persons who have a conviction for official misconduct in all three branches of government. If the Guam legislature truly believes in good government, it must enact laws that create a bad consequence for bad actions. Deterrence is an important theme of this AG's administration. People learn best through personal struggles and experiencing the pain from a criminal conviction of alienation, reflection, and opportunity to work hard to earn their way back into society. Making it easy with laws allowing convicts to again be in the henhouse is neither a smart policy decision nor does it deter crime. As stewards of the public monies and public trust, we must work together to protect the public monies and resources. We must balance compassion against protecting our public monies. Because the money is no one person's money, the strong interest in protecting that money is not as strong as protecting your own personal bank accounts. This is a dangerous situation. Bill 3037 makes the best choice and errs on the side of the more important interest in protecting all of our money. Bill 3037 makes the correct statement that an employee had his chance to work for the people of Guam and now must suffer the consequences for having violated that trust. This is deterrence. This is justice. Finally, Bill 3037 is consistent with this AG Moylan's administration tough on criminals legal policy. We must look to the best interests of our people and incorporate our mores and values into our laws that support law and order. Bad actions must have bad consequences. Otherwise, how will we teach our people and our children respect for one another and respect for themselves? Thank you for passing laws that make my job as Attorney General easier.
Thank you, General Moylan. We'll begin questions from the panel, from my colleagues. Senator Tello, do you have any questions at this point?
Mr. Chair, if I can go, I had an emergency call I had to take.
You got it. Senator Lujan, do you have any questions? No questions? Senator Blas, do you have any questions?
Yes, I do. Thank you very much, Mr. Chair. And thank you, Attorney General, for your testimony and for being here today.
Good morning, Senator.
I found it very interesting that, one of the suggestions, recommendations that you have is to basically then impose what can be deemed as a return of pay made to that employee.
Yes.
Can that be incorporated into a criminal statute, or does it have to go to a civil?
Well, thank you for the question. You're thinking in the right frame of mind. The person that gets the job that violates the statute could be charged criminally, arguably, but obviously civilly. So it would be part of the civil statute so that we wouldn't have to worry about prosecuting. The case would be they've been detected, the person turns in the resignation, and then walks away from the department. And the consequence of that should be that the people are made whole again, which is to have that person return the money, and the AG could prosecute or could pursue it civilly or criminally or, however, but it would be a legislative statement, so they wouldn't come when maybe an attorney general or says that, hey, you got to turn back the money. They says the statute doesn't provide for that. Then we'd have to litigate the whole matter, go up to the appellate court and so forth. So I thought that it might be a good, something to incorporate into the statute.
Okay, as opposed to, well, I was probably going to be even a little more stricter in this, and then there's not just the forfeit of the whatever pay that they had received, but their retirement.
That would be effective. The way that at least attorneys look at it, the less amount of court battle, the better, the less, because you have time, you have appeals, you have years that go by. When the suggestion that you gave is excellent, because whoever has the money has the advantage. You got to chase them down, as you're suggesting. When you hold the retirement, give them, or tax return, give the government the ability, basically by default, to take it from them, and then let them sue the government. That is actually a better way to do, well, it would add on to it, that the government would have the right to the money back, and then have those tools to, if they didn't give it up quickly, then they're going to be subject to withholding some asset that the government's holding of them.
Would it be necessary then for us to be able to effectuate through a amendment or a introduction of a civil statute as opposed to a criminal, or we can actually put it into this?
Yes, your suggestion could easily be incorporated as the way to get back that money that was improperly paid, wrongfully paid.
And the reason why I say this is just for everybody's edification. We're talking about an individual who has basically gone against the trust of the people of Guam, the people that he's supposed or she's supposed to serve in an official government capacity. That's the only way you're going to get charged with official misconduct.
Correct.
And I've always been of the belief that official misconduct in the statute that we have right now is actually very lenient. Okay, it's almost like a slap in the wrist. Don't do it again, and
Misdemeanor.
Yeah, and when you're entrusted with government funds, and you're entrusted to be able to provide these services in behalf of the government for the people, and you're going to breach that trust in this fashion, you're right. Official misconduct is like imprudent driving. In Title 16.
Right.
You don't know how fast he's going or how many times, but just go ahead and that's the catch-all. With regards to operating a motor vehicle. But I think that in this case, and I want to thank the author of this legislation. I appreciate her persistence in being able to move this through. But I also feel that we got to put more teeth in this, and in this thing, so that first off, it becomes inarguable, when an individual breaches the trust of the people of Guam, not the government, the people of Guam, in the capacity of being a government official. But, at the same time, the reason why I bring these suggestions, to light here, and with regard to not just the individual's pay per se or, pay increase is the retirement. That this individual, we may have just caught this individual now, but this individual could have assumably or presumably done this throughout their career and never got caught until that one point in time.
Yes, and with the way that you senators are trying to provide personnel resources, you literally could have a person convicted of official misconduct, be on retirement, come back into the government, and then you could grab the retirement. That would be an excellent way to give this teeth and to prevent the AG's office from having to chase people down, because it takes attorneys, resources, time. Time is the worst enemy, especially when you have officials that change, attorney generals that change. It's a good start, and with these additional comments, it would make it very effective.
You bring up a good point here. What is the determination, or what is the statute with regard to an individual who's retired, then, after their retirement, it is found that while they were in service, they actually committed this crime? What's the statute of limitations on that?
I don't have it offhand, but conceptually, the retirement is an earned benefit, right? You've acquired it, they certify it, and then you start receiving it. But it doesn't prevent the government from coming in and attaching it because of a obligation, like they do the tax returns.
Sure. But I'm talking with regard to the statute, the criminal, the crime in itself. Right now, as it stands, official misconduct.
Yes.
If an individual has retired out of government or has left government service, and then after their departure, then it is found that while they were in government service, they actually committed this crime of commission. What is the statute of limitations on this?
The statute of limitations does not start to run until they leave government service. And I have, by the way, our acting chief of the Government Corruption Division, Gloria Rudolph, here as well.
Okay.
And I can have her stand me corrected if I'm misstating a response here. The statute of limitations for official misconduct normally doesn't start to run until after the government official leaves government service.
Right.
It's a misdemeanor, so arguably 1 year after that service would be the statute of limitations. So the government would have to file charges, the people of Guam would have to file charges within 1 year of their leaving government service. That is my understanding. So.
Okay, well, the next question is official misconduct as a misdemeanor too lenient?
Senator, that is within your realm. When Deputy Rudolph gives her testimony, we were not going to be case-specific talking about any particular cases here, but she will explain the problems that we've had as an Attorney General's office in looking at certain statutes that don't have the contingency on leaving government service, like theft, whether the statute ran from the point of the theft occurring, because the statute, I don't think, has a catch-all that says that when you leave government service, that's when it starts to run. When you talk about more severe, as I said, this is a catch-all. Official misconduct is usually, you throw it in after several other crimes have been established, like felonies.
Sure.
And then, that's where the jury would decide if also it's official misconduct. But is it too lenient? I'll leave it to your, because again, usually you're charging them with something more severe. Mm-hmm. Official misconduct, it's such a catch-all that I really am not sure if we should increase it to a felony or keep it where it's at, but then increase the other statutes as it applies to government officials. So they don't get the benefit of what a theft statute might be until after they leave service. Because obviously when the government official is there, they can cover their tracks. They have the resources of the government to obscure information.
Well, that's interesting, because then brings up then now another question that came to my mind. Because if the official misconduct is actually a subsequent offense charged, as is in other cases, with regards to theft and drugs, if there was an instance where this official misconduct is actually the third or the fourth offense to be charged, can we apply, or could we, is there a suggestion, an idea of applying a compounding felony type provision, so that then
Yes.
if it was more than 3 different offenses, and then you have the official misconduct, it elevates it from a misdemeanor to a felony?
Your comprehension of the criminal code is good. You could do that. You would, and they do in other statutes as well.
Okay.
The compounding of it, the special circumstances, like they add in the dangerous weapon to, criminal charges, if there's a use of a weapon, those sorts of things.
Well, yeah, and I appreciate this conversation, and it's not that I want to be picky about this. Is like you, I hold the integrity of the office entrusted and position entrusted to you by the people of Guam, where you're serving in government service. And when you breach that trust, okay, there should be some dire and serious consequences to this.
Yes, sir.
Okay, and that's why, again, I applaud and I appreciate, and I'm honored to be a co-sponsor to this piece of legislation. I want to thank Senator Brown for her persistence in this. And, I may have more questions when, okay?
Thank you.
Ma'am,
Thank you, Senator.
you speak more because, I want to put more teeth to this, okay? And make sure that the jawbone don't break once we decide to bite it.
That when everybody knows out there that this is the consequence, they know they can't get back into government service, and if they try it, this is going to consequence. I'm 100% behind you. The deterrence stops crimes so that we don't have to chase them. Mm-hmm. So, Senator, thank you.
No, thank you very much. Thank you very much, Mr. Chair.
Thank you, Senator Bras. Senator Cananta, do you have any question? And, we do have one individual that, even though she's late, she's going to testify. And do you have any questions at this point for the Attorney General?
I don't have any questions, but I'll go ahead and yield the time to the next individual to testify.
Okay.
Thank you.
Senator Lujan, you had one question you wanted to put out before, or you want to wait for that? Okay, just a reminder, we ended at 10. We end this hearing at 10.
Yes, sir.
Okay, so Ms. Rudolph, next time come earlier, okay? Thank you. Because one of my colleagues was saying you're probably at court. No, you weren't, because the Attorney General's here. So please go ahead and
She's
read your
very hardworking.
testimony.
Thank you.
All right, thank you.
There we go. Good morning, Senators. My name is Gloria Rudolph. I'm an acting Deputy Attorney General from the Office of the Attorney General. I'm here to offer public testimony on behalf of myself and the Attorney General in support of Bill number 30-37. For too long, a loophole in Guam law has existed which permitted directors of government of Guam agencies to hire individuals who had been convicted of official misconduct. While this loophole existed, we've seen questionable exercises of discretion, such as the hiring of a former DOC guard who had just been convicted of official misconduct for assisting drug-addicted inmates with smuggling drugs into DOC, and then finding a position at none other than the Port Authority of Guam, an obvious, vulnerable point of entry for illegal drugs. Bill 30-37 would prohibit that and prevent any director from giving such criminal a second chance to live at the taxpayer's expense as a government employee. The crime of official misconduct is a catch-all provision in Guam law, which is used to prosecute government officers and employees whose conduct is clearly unlawful, but not necessarily contrary to any other, more specific statutes. Guam's statute is broadly worded to capture any misfeasance or nonfeasance in office that is not otherwise expressly prohibited by statute. Other jurisdictions that have codified this formulation of official misconduct are Alaska, Arkansas, Colorado, Delaware, Illinois, Indiana, Iowa, Kentucky, Louisiana, Maine, Minnesota, Montana, Nebraska, New Hampshire, New Jersey, New York, North Carolina, Northern Mariana Islands, Oregon, Tennessee, Texas, Utah, Washington, Wisconsin, and Wyoming. In 6 of these 26 jurisdictions, official misconduct can rise to the level of a felony. Guam is not one of those jurisdictions. Guam is, however, one of the 12 jurisdictions that prohibit public officials from knowingly refraining from performing a duty, quote, clearly inherent in the nature of the office, end quote. The phrase, quote, a duty which is clearly inherent in the nature of his office, end quote, has been interpreted as those unspecified duties that are so essential to the accomplishment of the purposes for which the office was created that they are clearly inherent in the nature of the office. To expand on this, GovGuam employees must have the benefit of specific standards to guide their conduct and should be subject to criminal penalties only for violation of those standards that are found to be especially vital to government. Our official misconduct statute is specific enough to provide notice and flexible enough to apply to the numerous and diverse instances wherein government power is abused. Bill 30-37 is necessary and appropriate because it is only appropriate that the legislature, not a court, provides specification of the ethical standards which apply to government employees, and that the legislature establish the appropriate sanctions for violations of those standards. To illustrate, I'd like to describe an extremely disturbing case involving a Guam bus driver. In 1992, Franklin Borja Camacho was charged with molesting 2 children, 9 and 10 years old, who were attending MU Lujan Elementary School and had the misfortune to be riders of Mr. Camacho's bus. Mr. Camacho was convicted by a jury of official misconduct for pinching the buttock of the 10-year-old girl who he was entrusted with transporting to and from school. She had the task of counting the children to ensure that everyone had boarded, and then of calling Mr. Camacho to get on board the bus. As he did this, he pinched the child on the buttock and told her to save that for me. The United States Ninth Circuit Court of Appeals later affirmed the Camacho conviction, finding that pinching the buttocks of a 10-year-old girl was an act relating to Camacho's office as a school bus driver, and that the Guam trial court did not abuse its discretion when it found that the probative value of evidence that Camacho had committed other acts of sexual contact with underage girls for years outweighed possible prejudice. During Camacho's trial, 2 other cases of sexual contact with children were revealed. These acts had occurred more than 4 years earlier in 1986, 1987, and 1988. In 1987, a 17-year-old girl was waiting at her bus stop when she saw Mr. Camacho driving his personal car. Mr. Camacho offered to drive her and the other girl home. After dropping off the other girl, Mr. Camacho drove the 17-year-old to a secluded area, parked, pulled his pants down, asked her to have sex with him, and forced her to touch his private parts. Another incident occurred in 1988 when a mother noticed that her 14-year-old daughter kept coming home late from school. She noticed that her daughter was spending an unusually long time getting ready for her weekly catechism class. One day, this mother followed her daughter and saw that instead of going into a classroom, her daughter went into a pickup truck with dark tinted windows. The mother approached the truck and pleaded with her daughter to exit. Mr. Camacho opened the door and the mother saw her daughter in the truck. Mr. Camacho admitted that he was having sex with her daughter and that he was aware of the consequences of having sex with a girl half his age. After the mother searched her daughter's room, she discovered numerous pictures of her daughter taken by Camacho, of her sitting in the driver's seat of a school bus pretending to be driving. Mr. Camacho was apparently punished by his employer for at least the 1988 incident, the one where he was having sex with a 14-year-old. That punishment was he was suspended for 15 days. He was suspended for 15 days and allowed to continue working as a bus driver. He was suspended for 15 days and allowed to be around even younger children who he subsequently molested. There are more instances of abuse of discretion by government directors where an employee is caught abusing his office, which this bill will finally put a stop to. Being in government is not like being in the public sector, in the private sector, I'm sorry about that. There is a measure of power that a person in a government office or position has that simply does not exist outside of government. There are numerous ways to damage the public's trust. It might be by dishonoring the oath of your office and imperiling the lives and safety of those who are trying to enforce law and order. It might be by taking advantage of the trust that a government position automatically affords you and using it as cover for wrongdoing. Or it might be by putting children in the presence of dangerous people and in dangerous places and doing nothing to remove the danger, or worse, ignoring and allowing the danger to remain. Our official misconduct statute takes account of this unique power and access to public resources that government employees have. If passed, Bill 30-37 would finally ensure that those who abuse the unique power of government and misuse, squander, or exploit their control over public resources will be expelled and prohibited from working in government again. Without this bill, we will continue to see more abuses of discretion. The people of Guam deserve to have the balance tipped in their favor when it comes to not allowing criminals back into the government of Guam. Thank you very much, Senator Brown, for your perseverance in ensuring that this bill is passed and enacted into law.
Thank you, Ms. Rudolph. Senator Cananta, did you have the question you wanted to pose? Because I think Senator Boss already completed his.
Yeah. Sidos Masi, Mr. Chair. Sidos Masi to the AG and Deputy Rudolph for your presence today and the AG's office for being here. I stand in support of 30-37. This bill will protect our government from any individuals who have been convicted of official misconduct from holding government positions. It is important that we hold our government officials to a standard of trust and reliability. We have an obligation to the people of Guam to ensure that their safety and security through the way we conduct our government affairs. As members of this legislature and this august body, we must ensure that we are doing all that we can to guarantee the trust and respect of our government and our people. Bill 30-37 is a step forward in the right direction to restoring faith in our government, and I am confident that this will be beneficial to the citizens and those we serve. That is why I'm in support of this bill, and I believe that it will help bring positive change in our government. It is critical that we hold our government officials accountable and build trust within our communities we serve. With that being said, thank you, Mr. Chair.
Thank you. I'd like to also recognize Senator Barnes joined us this morning. Senator Tello, do you have any questions?
Thank you, Mr. Chair, and thank you for giving me a little more time. Wow, after that testimony, that was an excellent testimony that you provided for us today to know the extent of what could happen when we don't prosecute even the slightest things, the smallest of things that can escalate into bigger. I mean, it's almost like turning a blind eye if you don't do anything about it. You know, they'll keep doing it and until it gets so bad that then it becomes our fault for not doing anything. So I'm very happy to be a part of this legislation. I do realize this is for the government of Guam. And it doesn't touch the private sector, where people can decide upon themselves whether they want to give somebody a second chance or feel that they can trust this person until something happens. Well, that's their decision, and I will never interfere on the private sector part. But this is the people's money. This is money that people entrusted in us. And you mentioned one of my favorite things I always say is that the public's trust. You know, that's so important, and we've been losing the public's trust so many times. This is an opportunity for the law to back us up, for us who really want to fight for the cause of providing that, bringing that trust back to the public. My concern here is I want to ensure that civil service, when they get involved with something like this, because we've heard many stories, they just get right back into the office and civil service will find them, oh, well, they didn't give the 60 days requirement, they didn't follow, the management didn't follow that, and yet the guy or the girl is guilty. They're outright guilty because it was a technicality. So how can we ensure that the Civil Service Commission, that if an individual is told you can't because there's a law that says, you know, you were convicted of official misconduct, and they want to protest it to civil service, how can we ensure that civil service follows that guideline, saying, no, none of the rules apply, 30 days, 60 days, none of that applies, the law is clear. Can this bill do that?
I believe it can, because the Civil Service Commission still stays subject to the legislature statutes. They're a creature of the legislature, and their jurisdiction is set by the legislature. This bill is very clear that they would not have a right to employment, whether they were in classified or unclassified service. I would also note, Senator Taitigui, that this probably would not get around for the governor pardons. So if the governor was to pardon a individual, they probably, because it's treated as an expungement, I understand. So that would probably allow the individual to apply as any other applicant.
Yes.
Just as a caveat to,
Okay.
it's just the Organic Act type of problem.
That allows that pardon, yeah,
benefit.
that's understandable. But, you know, that's the, people definitely question when
Well, the
governors
governor will be
do that,
subject, yes.
you know, and putting people back on the, and then, of course, it's their neck if that individual turns up to continue to be, you know, a criminal and hurt an individual, the worst case. You know, you mentioned about that, expungement and stuff, so it's the same thing for us as elected officials, they say that we cannot run if we've had official misconduct, right? If we are convicted of a, no, it's a moral turpitude. Can you give me the correct? I'm not sure if that's, yeah.
I'll have to take a look at the statute. I believe it's a felony, maybe. Yeah, and moral turpitude.
Moral turpitude, right? Which, is that moral turpitude kind of similar to official misconduct? Is that the kind of a same definition, around the same? Because I'd like to know the difference. And the reason why I bring this up is the same situation happened when there was a person elected as a senator, Senator Matt Rector at the time, and later on found out, because the records, we didn't find it. It was done, it happened in the States,
Right.
that he was convicted of moral turpitude, or even further than that, but he didn't, expose that at all. And he was smart enough to resign,
Yes.
because he knew he got caught. But, the damage was done. There was someone who came in number 16 who actually should have won that election.
Right.
And, that was such a detriment to that individual who worked hard to wanting to serve the people. And he didn't become the senator that he rightfully should have. So my question again, the difference between the two, moral turpitude versus official misconduct.
Well, official misconduct is the statute. We would have to research whether or not the term moral turpitude falls within that statute. It might go, again, there's other crimes like theft, I think qualifies as moral turpitude. A fraud, it clearly does. I cannot say offhand whether or not official misconduct is moral turpitude, because moral turpitude is not a crime. It's a description of what leads up to that crime, the fraudulent nature of an act, not concealing things that concealing things that should have been disclosed, stuff like that.
Yeah,
We use it in a lot of the ethical codes for lawyers and doctors.
Well, I hope we can dig into that and, provide a bill that's, covers everything to ensure that we're not bringing people into the government, who was, regardless of what type of crime they committed, whether it be moral turpitude or official misconduct, we don't bring them in. So if there's a way to ensure that same kind of restrictions that we as senators or any other elected official come into the government, should stand the same way with an appointment,
And
so.
Senator Tadegui, as I read this, I was just wondering, when the senators start discussing it, increasing the scope of it, because you've limited it just to official misconduct. But what you raise here is exactly what I was looking at, because the standard that you're setting for government employment is clearly higher. You're creating the integrity that has been lacking in our code, and especially as Deputy Rudolph explained in these specific situations, it's very scary, because we're a bureaucracy, such a big government, and it's very attractive to work for the government of Guam. The retirement benefits are much better than you would find in the normal private practice sector.
Thank you, and I hope you look into that clearly. And I just thank you again for being here and for your office for answering our calls. Thank you. Thank you, Mr. Chair.
Thank you, Senator Tadegui. And General Moylan, as I speak to the author, we're going to be looking at that and adding that official misconduct, you cannot run for office. I think there's ways to add it on the bill, but we'll just move along first. Sure. And we'll go to other testimony, but that's something I know the author is going to be probably reaching out to you.
Okay.
And finding out how we can put it in before the committee report comes out. Because I'm in support of this. If you did wrong, sorry, Charlie, go to the next bus stop. This is not the place where you get off. Senator
Yes,
Barnett,
Mr. Chairman.
do you have any questions? Or Senator Lujan first, because he had a follow-up on the testimony. Senator Lujan?
Thank you, Mr. Chairman. Morning, General, and
Morning.
good morning, Deputy Rudolph. I as well, in testimony of Ms. Rudolph, in regards to the 26 jurisdictions, and 6 of them had risen this to the level of felony, I as well would like to see this rise to the level of being a felonious act. And, General Moylan, you said earlier in regards to the expungement, and, most governors or administrations on their way out, that's when they do the
midnight expungements,
yeah.
right.
And, the pressure will be on a particular governor official misconduct will be looked at, they'll look at it as a slap on the wrist. Let's just go ahead and, we don't want you to lose your benefits and all that.
Second chance.
Yeah, absolutely. I think the pressure will be a lot stiffer if this rose to the level of being a felony rather than just being an official misconduct.
The legislature would clearly send a very strong message making official misconduct a felony. The only type of considerations you might want to consider is that going before a jury, the ability to, depending upon what the crime is, if the jury sees it as not as bad as another type of crime, like what Deputy Rudolph said, they may not convict. If they feel that the official misconduct wasn't as bad as it might be. So when I say that, I'm a little bit
Sure.
kind of worried about it a bit.
Sure.
Is that the juries often, in their wisdom, they consider many different things, and especially the jail time. Although they're not supposed to, this person could literally be put in jail for the next,
or maybe it
more
could
than a
be
year.
your first offense would be official misconduct. If you're convicted of another, it's no longer, the second one will be rise to a felony.
Yes, and like Senator Blas mentioned, if you put elements in there that if you're convicted of other things, the official misconduct is elevated, like you're suggesting.
Yeah.
That probably would be a good way to give the jury, because the jury may not want to convict for the felony,
Sure.
but they may want to convict for the misdemeanor.
Yeah, okay.
So.
Thank you, Mr. Chairman. Thank you.
Thank you. Senator Barnett?
Thank you, Mr. Chair. I also, obviously, I'm a co-sponsor, stand in support of the measure, but I did have some questions because and thank you, AG and Deputy AG, for showing up, and also for the work that your office is doing. I saw some comments on social media. Some people were complaining about these signs that you put up, right? But it was funny when me and my kids drive by these signs, we're always like, that's what you get, So I think I agree, it just serves it as a deterrent. So.
Thank you.
But I did have questions because you mentioned expungement, and so I thank Deputy Rudolph for a very specific testimony that I think recounted, one of the motives of the introduction of this bill. But we have seen other instances. Most recently, this year, there was an individual who was convicted of having sex with a student when he was a teacher, and then this individual later showed up employed elsewhere in the government, giving us typhoon updates during Typhoon Mawar. And so I wanted to ask about expungement, just maybe generally at first. Can you, if you're able to, if you have knowledge of the process for expungement, can you explain to us how that process happens?
The right of expungement is statutory, and the legislature has a specific statute that says when you can get an expungement, which is basically wiped off the record, can't be used against you. Usually nobody should have access to it except law enforcement officials. The law says by statute, where the statute specifically says a right to expungement. For instance, the ADC program, ADC 1 court, I believe that they successfully complete, even though that they may be guilty of that possession charge maybe, they have a right to have it expunged, so they cannot be punished for that, given the successful completion. The second one would be by trial. Obviously, you win the trial, found not guilty, a right of expungement, you're not guilty. And the third one, I believe, is if the Attorney General chooses not to prosecute you, like they open up a case against an individual and then somehow during the process they dismiss it, the statute says that, well, you're innocent, get it off your record. So that would be the expungement. Anything other than that, other than the governor or the Organic Act power, taking the local crime and pardoning it, that would be a Organic Act type of expungement. So I think those are, from my recollection, the only ones that you can expunge on. Not even the Attorney General can take, because a lot of people come to us, 10 years, 20 years, they were convicted of something, and they say, I've been good for the past 20 years, and I normally have to direct them to the governor or to the legislature to petition that. One the other day, marijuana. The convictions for marijuana, they're saying that since the legislature has changed its position on it, can we have it taken off our record because I can't get a job with some company, something like that, federal government. Those are the things left to the legislature to decide what can be expunged from your record. So
just for clarification, to the best of your knowledge, if an individual is convicted of official misconduct and whatever other charges, are they able later to petition the court and receive an expungement?
Normally not, but sometimes one of the tools for prosecutors is a person can admit to the expungement in the plea agreement, and if they can complete certain conditions before the judgment comes in, you can have a right to expungement. You know, just like any other case.
Right, yeah.
So you are correct in that after the judgment comes down, normally, unless you have the governor's ear, no expungement.
So would it basically be if all the conditions of the conviction or any like post-conviction, all those conditions are met, then an individual can apply for expungement? Is that how it works?
Right. You could normally, if you're talking a plea agreement situation, cannot. It has to be in that contract that says that I've done all these things.
Okay.
They call it a deferred plea.
Right.
Normally, and sometimes deferred pleas don't allow for expungement. It's up to the negotiation.
Right. So I'm just concerned that in addressing this loophole, as you guys have called it, we might be ignoring another loophole. So if someone is convicted of official misconduct and then through the conditions of the plea or whatever, able to later get, or it's expunged, then what do we as lawmakers do when we have a law, or we are entertaining a law that says if you're convicted, you can't be hired into Gov Guam? So let me just ask further, if they get an expungement of that conviction, does it show up anywhere? Is it still a court record, that conviction?
There are always court records, but who has access to it and what's the consequence of using it are what you're asking. When the expungement comes in, arguably, I think the general rule is you can't use that conviction to punish the person in any respect, normally. Now, the federal government, they like to look at it, and then for security clearances, you know, certain situations, they may use it, but that's a federal issue that's in a different analysis. Locally, once it's expunged, you're as if it never occurred. That's
Okay.
the rule. You go to GPD, ask for a police clearance, they show no convictions, and I don't even think they allow arrests to show up on police reports because you're still innocent even if you get arrested.
So technically, if we were to pass this bill and I had a conviction of official misconduct that was expunged, if I were to apply for a government of Guam job, are you saying that I would be able to get that job?
Correct.
Okay.
That's the power.
Do you think there's any way that we could address that without, you know, infringing on people's constitutional rights? Or? Because
it's in the Organic Act and our system of jurisprudence is set up around that specific word expungement, I don't think that it could easily be affected. Now, the civil, because this is a civil ramification of a criminal act, right? Because even if you required them to have to go through some sort of an application process, it still would be using that criminal conviction. There might be a civil, if they want to try to prove it civilly, there might be a way to do that. Because like the O.J. Simpson case, right? He was convicted, not guilty criminally, but they proved it civilly under that defendant. So there might be a way to craft it. It would be very, there would be like statute of limitations concerns for the civil side. So it's a difficult question. There might be a limited way to do it, but it would require a lot of resources to keep that person out. Usually, it's better, you know, the application process, like you guys are targeting right now, that would be an immediate no-go litmus test. Let us think about it, Senator,
Yeah,
and if I can get back with you, if there's a way to do it
when you
otherwise.
talk about the application process, are you maybe suggesting something that requires the applicant to disclose any convictions even if they were expunged? But does that kind of get into...
Let's raise an ugly situation that has occurred in the past year. Foster parent. They had the arrest, they had the information, it showed up as an arrest. They're innocent until proven guilty, but public health had the ability to say no. So that would be something like this, that they have the information, they know it occurred. What are they applying for? And what discretion are you giving the government employee that's reviewing the application process? So, yeah. That would be, because that in the situation that was encountered, and I believe it made some bills with the legislature and public hearings, that was, even if the person had gotten an expungement on it, the fact that he may have got off criminally, but civilly, he may have been a pedophile and should not be put with children. That is a standard that doesn't have to rely upon you're innocent. This is a standard of the danger to the children, the protection, the legislature's pronouncement that this is such a sensitive area that a fair hearing would have to be conducted, if information on that. Not that he got the expungement and was tried criminally, but that did it occur? And the civil standard is lower than the criminal standard. So they could find out that, yes, it did, like the O.J. Simpson. The jury believed, yes, he did murder that individual. So that, in a way, is how we're working through this, talking through it. You could put a requirement that it could be reviewed civilly.
Can I just ask, Mr. AG, so in the plea agreements that you're conducting in this term and moving forward, is expungement, or has expungement been a component in any of those plea agreements? Okay.
It is an important tool for a prosecutor to have the ability to negotiate plea agreements, because we have many situations where the evidence, if tried at trial, such as even like the CSC cases we talk about, I get that daily from our prosecutor that's assigned to that. The victim is changing her statement, the mother isn't supporting the victim's statement, and the defendant is willing to take a plea, but not what we were charging him with. So it's an important tool of any prosecutor in any jurisdiction to have that ability to offer that deferred plea, to weigh the balances of what's been alleged, what we can prove at trial, and what is fair. There's a lot of variables. So I would say we are doing it. It's not as easy as it was before with our AG's office,
right,
whether it's the general crimes or the government corruption division, especially so we have to look at all the facts. And that's why I've encouraged even our chief of police, with all these allegations that are coming out on like Candid News or other things, at the end of the process in your investigation, issue a report.
Right.
Because the people don't see what you guys are seeing. And that's what we're trying to have the personnel, in order to do it ourselves, government corruption division, because people need to know justice was done, and they need to see the variables. That's why, as I mentioned on these pedophile cases, it's not as easy as saying this person's a pedophile. The jury is we have, the system of justice where you have jurors is one of the most admirable systems in our government, our systems of government. These people have infinite wisdom. They balance the charge against the evidence versus compassion. I know they're not supposed to do compassion, but you see the wisdom in the jurors, and when we can't prove it to them, we could lose the entire, and that's how the prosecutor on the sex crimes normally says, we're either going to have to bend a little bit, or we're going to lose everything, and that predator goes back into that household, you know? So these are the things that prosecutors have to balance. But having the report is always a good thing, because it tells the people, it tells the legislature
right,
why we did a certain thing the way we had to.
Just one last question. Sorry, Mr. Chair, if I may. So what if we in the legislature, in order to address that, do you think that we have the ability to go in and amend the law and say, okay, if you're convicted of official misconduct, you can't get it expunged. It's just going to stay on your record forever?
With all due respect, Senator, the Organic Act, common law power of the Attorney General to decide to prosecute, it goes into the legislative's authority and the executive branch authority. The worst case scenario you have is where a felony was committed, a murder or something like that, and then the Attorney General says, for these reasons, I'm not going to prosecute this person. You know, that is a separate power of the executive to be able to choose to prosecute or not prosecute. So if the legislature was to tie the hands of the Attorney General that he must or she must prosecute this case, and this must be the result, I think that the legislature can say this must be the result, but it would cause the Attorney General to say it infringes upon what they call prosecutorial discretion. So these are good ideas to get to the end result, but usually when you elect a good Attorney General, when you elect a good public prosecutor, this is the type of, the public prosecutor is also an elected official and a member of the community. So to make that type of decision, you may be hanging yourself, as well as like the governor and the pardoning power. You know, if they're going to run a second term or something, to pardon somebody that is against public opinion, it's a one-term governor, that sort of thing.
Thank you, AG.
Can
Yes,
I just
ma'am.
add that unless it's in black and white in an agreement, it's very hard to get an expungement. Just petitioning the court, you know, unless you meet all the factors, there's rarely a case where you throw yourself on the mercy and then it's granted. So there are strict requirements for expungements, as it exists today. So, and the judges do a very good job of making sure that it's strictly adhered to.
Okay. I mean, I've heard, just differently from, you got to connect, you can get the expungement. So, and maybe that's something that, I need to send a FOIA for if I'm able to.
They do say that, and it's usually the governor. And again, that is his authority, her authority as the Organic Act.
Right. Yeah. Thank you, AG. Thank you, Deputy.
Thank you.
Thank you, Senator Burnett. Senator Brown.
Thank you very much, Mr. Chairman, and certainly to my colleagues, and certainly to Attorney General Moyland and your Deputy Attorney General Rudolph. Thank you for coming and providing your testimony with regards to this bill. I also noted, Mr. Chair, we had testimony from Mr. Lee Weber, who also submitted testimony last term when I introduced this bill, and we anticipate also testimony from Phil Flores, who again provided testimony last term when I introduced this bill. Unfortunately, this bill did not get out of committee last term. And certainly, as persistent as I am, and the examples that have been provided and others that we're aware of in the government, again, as I mentioned earlier in my opening comments, I think it's very important that when we assume these public positions to serve our community, and you're right, we do have additional powers that are granted to us, regardless of what position we serve in the government. You could be the inspector that works at Public Works. I mean, you could be the bus driver. You could be in all these other positions of government that give you the authority to make decisions for our people. And I think our primary role is to ensure public trust, and I think that's something that's eroded over the years. And when we see continued examples of this type of abuse of individuals that have already violated the public trust and then be returned to positions of importance in our government, and maybe providing them an opportunity once again to abuse public trust, I just don't think that learning curve is something the taxpayers of Guam should be burdened with. I think we need to be responsible when we assume our positions, and if we make a mistake and fail, if we commit a crime in our respective jobs, then so be it. Then we suffer the consequences. Because otherwise we are essentially opening the door to continued abuse of our people, their resources, and their money. And I don't think at the end of the day that's anything our law-abiding members want to see. I wanted to point out that in New Jersey, because we were talking and we probably will look at additional penalties to add as a result of the testimony provided. In New Jersey, essentially official misconduct is looked at as a second-degree offense. And in New Jersey, if you're convicted of official misconduct, you can serve up to 5 to 10 years of imprisonment and up to $150,000 penalty. That is incredibly severe. But I think it also sends out a very strong message. I don't know, we'll see what consensus we could get here. But obviously from the testimony, there needs to be a little more than just not being reemployed in the government of Guam. Perhaps there should be additional burden put on individuals that commit these type of crimes. Because when you hear them, they're very disturbing. I mean, it's one thing, you could have a public officials taking money under the table to approve a building permit. And I've encountered that. I've been at DPW. It's interesting why people all of a sudden disappear and retire. Because these type of offenses are not as uncommon as we'd like to think. But then is it simply they get charged for doing that, or is there another layer that gets added of burden so that hopefully a public official will not just think twice, maybe they think 3 or 4 times before they commit these type of offenses, because they really have to weigh the consequence. Is it worth it? If I get caught and I get prosecuted, is it worth it? And right now it's almost like a free pass. You just simply wait, buy your time, and then you come back again. And I think that just isn't how it should be. I think we need to ensure moving forward, because we don't have such a good past, but moving forward, that those of us, all of us that work for the government, that work for the people, should ensure public trust and should be held responsible and accountable if we misuse or abuse the position and the authority to which our people have temporarily granted us. So with that, Mr. Chair, thank you, and thank you to my colleagues. Again, thank you to the Attorney General and to Deputy Attorney General Rudolph for being here and providing your testimony on this bill. I appreciate your input. Thank you.
Thank you, Senator Brown. That being said, I'd like to also thank everyone for attending this hearing and for providing feedback and suggestion. Bill 3, I will be working with the author of the bill so we can make the appropriate amendments so we can tighten it up a little bit, just a little bit. The Bill 30-37, the COR public hearing is now adjourned. The time now is 10:04. Please be safe and have a nice day. Thank you. We will now recess and prepare for Bill 107-37. Thank you. Good morning and good afternoon. We will now proceed on to half a day. The Committee on General Government Operation and Appropriation now called to order. Today's Thursday, September 14. The time now is 10:11. In compliance with the open government law, the notice for this public hearing were posted on the Guam Public Notice Portal KGTF PBS Channel 12 and disseminated via email to all senators and all main media broadcasting outlets on Thursday, December 7th, and again on Tuesday, September 12th. The item we'll be discussing in this public hearing is Bill 107-37 LS, introduced by myself, Senator Agustin, co-sponsored by Senator Roy Canata, Senator Vice Speaker Tina Rose Munoz-Barnes, Senator Dwayne Snickles, Senator William Parkinson, and Senator Amanda Shelton. An act to appropriate $500,000 from the general fund to the Guam Housing Corporation relative to funding and maintaining the Guam Housing Corporation's Rural Housing Service Escrow Savings Account for affordable housing. Physical note for Bill 107-37 CR was requested on May 3rd. It was received and disseminated to all senators via email by Committee on Rules on May 15. Those participating on behalf of 107-37 CR are invited to the panel, and we have Mr. Carlos Camacho. The general rules for this public hearing: please provide my legislative staff with any document for distribution and for photocopying. Panel members are asked to remain in the room for questions or for additional testimony that may be desired by members of the committee. Questions and testimonies shall be confined to the substance or nature of the agenda. Personal inference that the character or motive of any senator or any individual testifying is not permitted. Any violation of this general rule of conduct will result in removal from the public hearing. Proper form and decorum shall be practiced by all present in the public hearing room for these proceedings. Individuals who fail to maintain proper form and decorum will be restricted from participating and will be escorted from the room. When you speak, please make sure that the microphone is on and that you speak into the microphone. Please state your name and your title for the record. I'd like to acknowledge my colleagues that have joined me this morning. We have my Vice Chair, Senator Tello Taidegui, Senator Roy Canata, and Senator Lujan. And with that, I'll read my opening statement. On Bill 107-37 LS. For some time now, the price of home ownership has skyrocketed beyond its affordability for many families here at home, and we are working in ways to address the abilities of families to build homes on properties that they own or have deeded or leased for such purpose to uplift a family unit. Homes for sale in Guam are averaging anywhere from $420,000, and real property in Guam has been scarce and it is difficult to find a decent single home dwelling that is affordable. The Guam Housing Corporation and the U.S. Department of Agricultural Rural Housing Services is in partnership through a memorandum of understanding. Their MOU is in respect to making, guaranteeing, and servicing of USDA RHS single-home family housing loans to owners and leases of Guam lands. Under Title V of the Housing Act of 1949, RHS is prepared to provide loans and grants to low-income and very low-income. GHC will facilitate and serve as the guarantor of such loans through an escrow savings account to provide a source of funds to protect RHS from borrower defaults on these loans on Guam. Bill 107 is to appropriate the initial minimum deposit of $500,000 from the general fund. And since we are ending FY23, the source of funding will be amended to reflect FY23 unappropriated excess revenue as all FY24 projected revenues have been appropriated. GHC must ensure that such funds are not pledged or taken from any purpose than as a reserve to partially satisfy obligations working towards providing affordable housing to the people of Guam. I'd ask Mr. Camacho to provide his testimony, sir. Yeah, just turn it on.
Good morning, Senators and Chairman. Thank you for your vision on providing a funding seed for this Guam Housing escrow account to finally put I call it their fourth financial resources to assist the families of Guam. As you can recall, if I can give a little history, in 1995, Guam Housing Corporation signed an MOU with Veterans Affairs for the Native American Loan Program to have that program incorporated in their portfolio. In 2005, they signed what you're funding today, the MOU with USDA, which is the escrow funds, so that the Section 502, which is the loans for these families to build their home, or Section 504, which is a combination of loans and grants to assist these families to improve their homes. That's in 2005. Their existing portfolios, the Guam Housing Corporation funding source that they have, internally they have. So those are the three resources. Not until, was it 2-3 years ago, when you had the Dave Davis lawsuit that brought up the Fair Housing Act violation. Thanks to this body, thanks to Speaker Talahi, you guys worked on legislation and policy, passed the policy, and the Department of Justice approved it, and we're back on track. We're back on track in providing these federal resources to the Chamorro Land Trust recipients. Now, the $500,000 may not seem like a lot of money to guarantee thousands of families to build their homes. So I know Mr. Diego from USA is not here. They're all in Hawaii right now under training, but he've always mentioned a point like for the Marshall Islands. They did something very similar, $500,000, and they provided close to $8 million worth of home loans to the Marshall Islands constituency. We are hoping that that same positive economic effect will happen to these land trust families. The great news about this program, it will have the fourth, or they have an existing MOU, like I said, but it was halted back from that lawsuit which you guys resolved. And hopefully, the latest I got, and I can't speak on behalf of USDA or Guam Housing, I understand they're updating their MOU, because that was since 2005, subject to this legislation, so they could finally get this program back in place for the land trust recipients. And just for the record, I am not a land trust recipient, so I am not benefiting from this loan program. It is targeted to the low to very low income families. In 2010, I worked with Bureau of Planning as a volunteer member. We've created CDPs in Guam, Census Designated Place. Why that's very important? This program is population driven. Derrida at that time's population was 40-some thousand. Jigo was 20-some thousand, over 20-some thousand, did not qualify. So in 2010, we created CDPs, which was finally adopted by Bureau of Planning and by the U.S. Census Tract. Now the whole island of Guam, and you guys can confirm that with the Bureau of Planning, has designated CDPs. So majority of these land trust properties finally qualify under the population criteria. Now what's missing now is this MOU, which they have presently, and they're amending, and the final resources, this $500,000 escrow funds, which goes in good faith to show that the government's putting that to provide this program to its constituency base. I was listening to the Chamorro Land Trust Commission the last 2 weeks. A lot of these guys were getting their SBA Mawar disaster loan. Unfortunately, their requirement right now, to what I heard through their public hearing, is a dollar-for-dollar match. Their problem is they don't have the financial resources to do that. So this body, through the budget hearing, passed $1 million bridge financing to at least assist some families to get the SBA loan. The reason I say that is, if this MOU is finally provided again, their interest rate is as low as 1%, at the floor rate at 3.87%, with a lot of federal safeguards, unlike your regular portfolio. And later, you can probably ask that question to USDA, but I'll give you a few of their highlights. One, if there was a presidential declared disaster just like Mawar, and if the families were impacted, their loan portfolio would be halted or set aside until they recover. Minimum of 6 months to a year, according to USDA, and that can be reconfirmed. In the event a household has lost their jobs and they needed to restructure their liability, that's how flexible they are. They can give up to 1 to 2 years to have them get back their workforce or look into another job. They're there to help them into home ownership. But again, that can be re-verified with USDA if you guys are interested in asking them directly. So at the end of the day, I do support this endeavor. I know this was introduced several months ago, then Mawar came, and then you had the budget hearing. But this is perfect timing because this will be a fourth tool, as I said, for Guam Housing to sharpen dot their I's, cross their T's with their MOU. And I understand they're modifying it with USDA now, and hopefully get that going and provide this loan program and grant to the Chamorro Land Trust recipients. Again, I support your endeavor of 107-37. Thank you very much.
Thank you, Mr. Carlos. Senator Roy, do you have any questions you'd like to pose to Mr. Carlos?
No questions. Just wanted to acknowledge him as being a very good individual regarding any housing effort. His tireless efforts in finding affordable housing has always been a great trait of his. You've always stood by the little people and putting families before profit. You've been a housing czar, and as the chairman on Committee of Housing, I definitely support this bill, and I'm very glad to be a co-sponsor of this measure, and in any way I want to help our people secure a safe and comfortable housing unit. Thank you, Mr. Chair.
Thank you. Senator Lujan, do you have any questions?
No questions, just a comment, but good morning, Mr. Camacho. Again, like my previous colleague, of course, had mentioned, you're kind of like the godfather of course, low-income housing here on Guam and an advocate for the little guy, basically. But thank you again for all your efforts and your continued efforts in doing as such. So thank you very much. And I got no questions at this point. Thank you very much, Mr. Chair.
Thank you. Senator Brown, do you have any questions for Mr. Carlos?
Thank you, Mr. Chairman. No, I don't. I mean, I've known Carlos since we used to be youth Congress members over 40-something years ago in these very halls, so I have no questions for Mr. Camacho. I just do want to note, certainly, and I very much am supportive of the program. I think the only thing I want to get clear is to ensure that the amount that's requested to be appropriated is tangible, because we're still waiting for the audit. We're still waiting to find out if this, at least according to what BBMR has written here, this 15.9 million, which is an unaudited amount, we need to verify that the funding is there so that we can actually give you tangible money, because as you know, we just completed the budget process, and there are a significant amount of appropriations beyond the revenue forecast for this particular year. So I just want to make sure that when this bill's on the floor and we're entertaining it, that it's tangible, real money, so that that money can be put in place to assist those in our community that obviously are in desperate needs of homes. Because homes are now, thank goodness we built our homes for those of us that have, because we had to do it now. Even with our salaries and what we're earning, it would almost be cost prohibitive. And we're losing a lot of our young people that are leaving the island, and even ours that even are a little older that leave Guam simply because they either are not able to afford a home or because the cost of living has become so high that they look for opportunities elsewhere rather than investing in their island and in their homes. So I'm very supportive of the concept. Certainly, you know, you're deserving of all the recognition that you've had, Carlos Camacho, and all the work that you've done, and all the many families in this community that you've already, you know, through your vision, through your effort, and through your persistence in following through. And I have to say that you have done that. I mean, your work is tangible and it's visible for all of us to see in this community. It's something that you haven't needed to do, but you've done it, and you're most deserving of being recognized for your continued efforts to help those in our community that really need the help. Your talents have been well invested over the years, and I have to say, my dear colleague, I'm very proud of you. I'm very proud of all that you've done for our people. So I just want to make sure that this is real money so that we can support Guam Housing and their efforts. And gosh, I think you're tearing me up. It's a rare moment. To help these families so that these agreements can get in place and we can get more federal resources here to help our people. Thank you, Mr. Chairman. Thank you also to Guam Housing that's present here today. Thank you.
Thank you, Senator Brown. Senator Tyree?
I don't know about you, Carlos, but I was tearing, listening to Senator Brown talk about you and all the great things you've done. I've just, started tearing up and choking, because I think many of us had the opportunity to work with you and see all the good that you do for the people of Guam so selflessly. You just want to make sure people have a good home to stay in. And so I don't have any questions. I too am concerned, again, share the same sentiments. I do realize this fiscal note was done in May, which May 15th, 2023. So it's, we're going to be in October. This bill is not going to be heard until probably on the session floor until October. So that means we're already in the fiscal year of FY24. So is this FY23 money? Is this FY24 money that is coming from the general fund? And just putting general fund in there, if it's FY24, then we have basically have an unbalanced budget for $500,000. It's a concern. Mr. Chair, is Guam Housing going to come up and testify at all?
They're here. They submitted
To ask any
written
questions?
testimony.
And can I have the director to come up and ask a couple questions I have?
Yeah.
You're the acting?
Why don't you go ahead and come up? She's calling her back up, you know what I mean?
Okay. And just, everyone can introduce himself and your position.
Yes.
But thank you, Carlos, while they're settling in. Thank you so much for all your work. And of course, if I have any questions, I know who to call. You're on my speed dial, by the way.
Mary Guerrero from Guam Housing, and I'm the loan administrator. Thank you.
Good morning, Senators. I'm Angie Camacho, the manager at Guam Housing Corporation.
Happening. Good morning. I'm Patricia Kier. I'm the special assistant to the President Pangilinan.
Okay. So I'll address this question to either one of you, to answer. How soon do you need this funding? Is it something that there's a timeline involved in this?
Okay, for us, for our loan portfolio, we're not requiring the escrow account. We continue to receive, process, and approve, pre-approve any applications that we receive from the from applicants that are leasing on Chamorro Land Trust properties. So that continues irrespective. But this particular one, I guess when money is available, then that would be when a different source of funding for the Chamorro Land Trust lessees to avail themselves if they're not able to get their loan assistance from Guam Housing, because this program that rural development provides is a subsidized program, so their interest rates are going to be dependent on their income, and they can go as low as 1%. And I know that they can go for a term of 38 years, which we have also amended our policy, because we know that really currently with individuals is them finding a contractor, or the cost of homes is a lot. It's even if they're building and they can reduce some of the expenses, make it modest, it's still very expensive. So that's where we're at. But we continue without the escrow account. This is for rural development, and we will like to ensure that there's other available programs that's available to the lessees other than Guam Housing, because the Veterans Affairs also provide loans for Chamorro Trust lessees, and they don't require either the escrow. They must have another source.
Okay, so they're not requiring that there's an escrow account because the escrow account is still available, is what you're saying?
There's no escrow account right now.
So this 500,000 would fund an account based on an MOU between Department of Agriculture, U.S. Federals, versus Guam together, put it together. Great. So that's why I was wondering if it's an MOU and if there was a timeline that's required for this to get into place. I just wanted to know, so there is none. The second one is, the money is supposed to stay in the account based on a permit or, how the fund is built for anyone in default. Okay. How many people that you've given loans out have been in default in the last 2 years?
There are some accounts that are late, but they're still performing. They're still within the 60 days, and their reasons are valid for being behind. But really, in our portfolio, the delinquency is not a high amount compared to what the total portfolio. We had over 4 million, and we've had some that already paid off their loan, people that are ahead of schedule. So they're not really based on their performance on our portfolio. It's not really something that requires for us to go to look for notice of acceleration unless it's going into probate. That'll be the only time that we would move forward on something. But other than that, those that we have provided loans are performing loans. So it's not a concern. Based on that, we're, because this escrow account is going to be in the event they have to pursue foreclosure. And because they cannot foreclose and take title to the property, this account then would be used to satisfy what is still outstanding with rural development, but not Guam Housing and not Veterans Affairs, just rural development.
And has that been in place to give you some data and information on like I said, individuals who go through foreclosures? How many of you anticipated in the last, well, not anticipated, but how many in the last couple years have gone into that type of foreclosure?
None have
None?
had nothing.
So then it's anticipated this 500,000 is going to be sitting in this account because technically you're not going to have to really use it, right?
Right, because rural development would have to ensure that whatever servicing action they can take prior to pursuing foreclosure, notice of acceleration, that would have to be explored before they go that route. So,
right. And based on my understanding, it's very rare. So we can just anticipate. Now, is there a reason why it's 500,000 and not 100,000 or $1 million in this account? Why 500,000?
I'm going to have to defer to rural development. I think that's the amount they felt comfortable because they were looking at making available funds.
Was it their decision to have 500,000, the U.S. Agriculture?
Yes, I'm pretty sure that's
where
decision,
the 500 came from. Okay.
Because it's their program.
Well, once again, the fiscal note on this was done in earlier May this year. I don't want to go into the next fiscal year where we've appropriated money and it's an unbalanced budget. So either we, make an amendment to this bill to clearly identify where the money is coming from instead of just saying general fund. Is it FY22 excess revenue? Is it FY23 excess revenue? Is it just, we adjust the budget bill? So looking forward to seeing how this goes through because, something like this, of course, we support. But like you said earlier, this money is going to sit in an account on something that may not even be used for, like you said, it's very rare that there's a foreclosure or something like that this money would be used. So thank you. Thank you.
Does any of my colleagues would like to ask any questions? Because I have no problem with this, and I'm not going to be pushing this bill so fast. And the reason why is because they're identifying the funding source. and being that USDA, this is what they recommended, was 500,000, because it's like what Mr. Carlos mentioned earlier. In another area, it revealed there was $8 million available for folks to borrow. And if it goes through Guam, I mean, if Guam can benefit, then why not? And with that, I don't hear any real objection to the bill. It's a matter of just timing. And the audit will be coming out on 22 very soon. And if it comes up and is promising, this bill may just shift to tap that source of funding, and then we'll move on. But you know, I'm not really too worried. You've already described Guam Housing as a good record. You have good clients. Everything is working out, and we just keep hoping for the best for the people of Guam. And if this is another way of helping the people of Guam, then let's do it. That's the key. That being said, there's no one else to present any other testimony. The committee will close this hearing. Again, I want to thank everyone for attending this hearing and for providing feedback and suggestions. Bill 107-37 COR, public hearing is now adjourned. The time now is 10:37. Please be safe and have a nice day. Thank you.